Okay, thank you, ladies and gentlemen. We'll continue the discussion, but before I call on the next speaker on the list, I just wanted to make a rather technical change to the question that is in board books at page 3, and it's a very small correction, but it more accurately tracks the language of the Federation's approval. So the question as amended will be, given that the Federation Approval Committee has provided preliminary approval of the TWU law program, etc., rather than provided conditional approval, because that's the resolution that was passed at the Federation speaks to preliminary approval of the TWU law program. So just the change of one word.
Just a point of order, can you explain, is there a difference between the two that we should know?
No.
Thank you.
It's just simply to track the language of the resolution that was passed by the Council of the Federation. Or rather, the approval that was given by the Approval Committee was a preliminary approval. That's more accurately how to frame that change. All right? So, we left off with Mr. Faulkner, and next on the list is Ms. McLean, who is on the phone. You need to take attendance.
The conference is in lecture mode.
I think what we'll do is we'll ask.
The conference is no longer in lecture mode.
Ms. McLean, before I ask you to make your remarks, I should use the opportunity while we've got everybody on the phone. Is there anyone on the phone right now that wishes to be added to the speakers list at this time?
Do you want to know who's on the phone now or new people?
Well, actually, I guess we can go through, I guess we should go through the list again and see if there's anybody who has left or joined us. Okay. I'm going to go through the list again. Robert Armstrong. Constance Backhouse.
Present.
Larry Bannock. He's in the room, sorry, he's in the room. Mr. Copeland. Paul Copeland. Mr. Epstein. Mr. Eustace. Mr. Furlong. Thank you. Mr. McLean, Ms. McLean, you're on the phone. I'm at your next.
Yes, I'm on the phone.
Thank you.
Yes, I'm here.
Ms. Richardson.
Present.
Thank you. Ms. Ross. Ms. Strasberg.
Present.
Mr. Wright. Mr. Scarfone.
Present.
Thank you. I think Mr. Sandler was here. He's gone. I don't think he's on the phone now. Mr. Maines, are you still on the phone? Mr. Yacchetti.
I am here, sir.
Thank you. Mr. Hunter. Mr. Hunter. All right. Is there anyone whose name, is there anyone on the phone whose name I have not called?
It says it's Ron May. Did you get my present?
Yes, we do now. Thank you, Mr. Maines.
Right, thanks.
Is there anyone on the phone whose name I have not called? All right. Is there anyone on the phone who wishes to? Is there anyone on the phone who wishes to be added to the speakers list at this time? All right. Ms. McLean, you have the floor.
Thank you, Mr. Treasurer. I'd like to say hello to the representatives of the Trinity Western University. I'm sorry I can't be there, and I can't see their wonderful council, who I know very well. I would also like, Mr. Treasurer, to commend you and the staff for the wonderful materials that you have put together. The written background material record is excellent, and it answers many of the questions that have been troubling us all the way through this process. I agree that during my term, this is the most important issue that's ever, I think, faced the benchers, and I also now have been corrected by Mr. Sway, so this is a much more it's a longer period of time over which we have been asked to deal with such a very important issue. Now, I am not going to speak on the merits of the issue because I cannot begin to express it in the way it has already been expressed. What I have is a very practical question arising out of the materials. Specifically, when the Trinity Western University made their submissions to the Federation in their report, they talked about why the rationale for the law school. And in that submission, which you'll find at board books on page 74, in that submission they say one of the benefits is to sole practitioners and small law firms. And they go on and they indicate that it's the benefit is to the sole practitioners and small law firms in British Columbia. And they have addressed all their comments to the lawyers and answering the concerns of the Law Society of British Columbia, not the Law Society of Upper Canada. So my question is this: why today, before this matter is heard by the Law Society of British Columbia, which I understand is to be tomorrow, are we asked to consider this matter? And furthermore, why are we asked to consider this matter before final determination has been made by the application to the BC Law Society? I would have thought that the law school would have been better served to address the issue in one jurisdiction rather than spreading itself as it has in the multiple jurisdictions, including this one, which I would submit is probably one of the most difficult jurisdictions for them to address. And for that reason, I would like an answer to that question, perhaps in a written response.
Well,
Mr.
if I
Treasurer,
yes, Ms. McLean, if I may say, I'm not sure that that's a question that PWU would be in a position to answer. Clearly, the law societies of the provinces and territories have the legislative authority delegated to them to determine who can be admitted to their provincial bar. And as I've mentioned before, the policy of this law society, which it adopted in 2011, was that we would no longer be required in a typical case to examine a particular law school program once the approval committee had approved it. But as you will know from the history of this matter, there has been a view that the national standard omits consideration of the issues that are being debated in the law societies across the country. And despite our policy that we adopted in 2011, the bylaw of our law society requires Convocation to consider the merits of this particular application, and indeed allows the law society to consider the appropriateness of any law degree program. I'm sorry I can't give you a better answer than that at the moment, but that's the rationale for the application being considered in various provinces at different times.
Thank you, Mr. Treasurer. I guess the question is that they have scoped their application to a particular province, and I'm just, wondering why we are debating this today, that's all. Thank you for your time.
Thank you. Do you have any other points you wish to address, Ms. McLean, or is that?
No, I don't, Mr. Chairman. That was the question.
Thank you. So next on the list is, but obviously if Trinity Western wishes to augment or wishes to contribute to an explanation of why they're here, I'm sure they will not feel precluded by doing so if they wish to address that point. Ms. Symes, can I call on you now, please?
The conference is in lecture mode.
And while Ms. Symes is going up to the podium, I can advise that we have Ms. Symes will be followed by Mr. Callahan, and then Mr. Silverstein, and I think Ms. Murchie is asked to be removed from the list. And Mr. Silverstein will be followed by Mr. Evans. And sorry, Mr. Campion. Sorry, Mr. Campion before Mr. Evans. Thank you, Mr. Campion. Ms. Symes, please. Thank you.
Treasurer, representatives of Trinity Western University and their council, I don't intend to repeat the various questions that were asked. I want to go into a new area and ask my questions with respect to those areas. I begin, of course, with the decision that is before us, that we must make, is to be done in the public interest. And part of the informing of that public interest is the statement from the Supreme Court of Canada and Dore, which is that we are to use charter values, which includes upholding dignity and respect for all Canadians, including on the basis of sex, sexual orientation, marital status, and religion. And Tremontian, the court said to us, we must, in making our decision, interpret and apply human rights legislation. And of course, for us, it is Ontario human rights legislation. Now, I make these remarks as an out Christian. We sometimes, we have greater ease in talking about sex and money, but religion is in fact one of our last taboos. And so I say that, I make these remarks as an out Christian. In Canada, there is no hierarchy of rights. And so we can't simply say that religion trumps sexual orientation or the other way around. What the Supreme Court of Canada said in NS is that when there are competing interests, then the decision maker must strike a just and proportional balance between freedom of religion on one hand and freedom from discrimination on sex, sexual orientation, marital status, etc. But what the court said is before you enter into the balancing is first answer the question, are the competing interests truly engaged on these facts? And if the answer to that is yes, resolve those claims then to try and preserve both rights. So my first question will be, are the competing interests truly engaged on these facts? So let's look at it from the point of view of freedom from discrimination on the basis of sex, sexual orientation, and marital status. There is no question, based on the materials before Convocation, that gays and lesbians cannot enjoy sexual relationship even if they are married. The covenant prohibits it. Well, what about the line, it's okay to be gay, just no sex. Hate the sin, love the sinner. It's well-established law, now for a long time in Canada, beginning first with Freend, that sexual orientation includes being the person. It includes the right to have sex. It does not merely protect eunuchs. Okay, so what is this covenant? And I ask the Trinity question. As I read the covenant, it is not aspirational or merely theoretical. How on earth could we possibly disagree with an institution that upholds integrity, honor, justice, etc.? But the covenant as I read it, and I ask for further clarification, applies not only to behavior on campus, but also off campus. And here's the kicker. Failure to comply with the covenant invokes discipline up to and including expulsion. Now, that covenant has changed, as I read it, from the 2001 case involving teachers. So, for freedom from discrimination on the basis of sex, sexual orientation, and marital status, it is clearly engaged. There is evidence before Convocation that either actions are prohibited and will not take place, or that there is a breach of the covenant subject to discipline, the most, of course, powerful one being expulsion. But what about freedom of religion? My first question is it really engaged? On these facts, that is, a law school at a Christian university, is freedom of religion really engaged as the Supreme Court of Canada set out in NS? But there's no requirement that a person whose personal religious beliefs prohibits abortions must have an abortion. There is no requirement that a lesbian must have sex, even within marriage. No requirement that an unmarried person must have sex. Freedom of religion, I suggest, in Canada protects beliefs. But when those actions extend to compelling or prohibiting actions of others, that is when there is a conflict. Now, this is not an application for an accreditation of a divinity school. This is not a code or a covenant to associate, to ascertain whether or not Mary or John or whatever should become a pastor in the evangelical church. I suggest, asked of Trinity Western University, that if that were the case before Convocation, that is clearly protected by freedom of religion. Freedom of religion is clearly engaged in a divinity school where you're selecting leaders for a faith. But this is a law school. And surely one of its purposes, and if you read Trinity Western's submissions to the Law Federation, it's in part to prepare students to practice law. And that part of it, other than to be done with integrity, with honor, truthfulness, and injustice, freedom of religion, I suggest, may not be engaged. And so that's my first question. What is Trinity Western's response to the Supreme Court of Canada in NS as to whether or not in these particular facts freedom of religion is in fact engaged? If the answer to that question is yes, let's turn then to the other side. And let's look at those same facts and determine how the Supreme Court of Canada has given us direction in terms of balancing. I suggest that the most helpful direction comes from the Whatcott decision. It's a unanimous decision of the court in 2013. I think it is the latest pronouncement. It is a substantial change from its prior decisions with respect to limits on freedom of speech, and it is in fact a different viewpoint of these issues than the BCCT case in 2001. It involved hate speech provisions of the Saskatchewan Human Rights Code that were challenged on the basis of freedom of expression, Section 2B, but the second part, which is often not referred to, freedom of religion, 2A. Mr. Whatcott, clearly a very earnest man, You may have met him at the Canadian Bar Association in Saskatoon, picketing out front of the convention center. He believes that homosexuals, who he refers to as sodomites, must be kept out of public schools because they provide a risk to school children. And he gave evidence in the tribunal that God is calling him to spread this gospel. This is his mission, his freedom of religion to spread pamphlets throughout Regina, Saskatoon, and other places that homosexuals have no place in public schools because it would place school children at risk. And the second part, and the smaller part of the Whatcott decision, deals with the freedom of religion under 2A. Now, how did the court direct that these were to be balanced? The court said that an infringement of Section 2A will exist if the claimant sincerely holds a belief or practice that has a nexus with religion. And secondly, the provision interferes with the claimant's ability to act in accordance with his or her religious beliefs. This interference must be more than trivial or insubstantial, such that it threatens actual religious beliefs or conduct. Okay. Now, what did the court do about Mr. Whatcott's belief that homosexuals should not be permitted in public schools? It said, when reconciling the charter rights and values, freedom of religion and the right to equality accorded to all residents of Saskatchewan must coexist. But they went on to say it doesn't matter whether the expression is religiously motivated or not. If viewed objectively, the publication of these views exposes vulnerable groups to detestation, these are the magic words in the hate provisions, detestation and vilification, then religious expression is captured by the legislative prohibition that is found in the hate provisions of the Saskatchewan Code. They said, Whatcott's freedom to preach against same-sex activities and to seek to convert others to his view is preserved. His freedom to express these views is unlimited, except they may not be conveyed through hate speech. So my question then to Trinity Western. The Supreme Court has said that Trinity Western University is free to believe, to teach, to preach to its students religious beliefs which say that abortion, homosexuality, and sex outside marriage are morally wrong, in fact a sin. But this is a law school. It's not a school of divinity. And the question really is, why should the Law Society accredit Trinity Western University, which will, as a number of my colleagues have said, discourage and prevent gays, lesbians, bisexuals, and trans from applying to your law school, but also once there will subject them to isolation and to discipline, including expulsion, if they act consistent with their true nature. To do so is in fact inconsistent with charter values. So my first question to Trinity Western, if you can help me, how is freedom of religion engaged? in having a new law school and in coming to Ontario for accreditation of it, how is your freedom of religion engaged? And the second question, if freedom of religion is engaged, how does Trinity Western University propose that the equality rights of women, of gay, lesbian, bisexual, trans, and unmarried be preserved? Because religion doesn't trump. Thank you.
Mr. Callahan, Mr. Callahan, go ahead.
Go ahead.
Go ahead. I just had written down the wrong John in my list.
The wrong John?
I had.
Well,
I don't think the order matters.
I hope
Thank you,
it doesn't. I have 3 sets of notes here. I have my green notes, my type notes,
You'll
my
have to do
handwritten
one set
notes,
first.
hand notes and written notes I did before I just got up here. This is a difficult issue. This doesn't allow for an easy answer. I appreciate Venture Science who kindly reviewed some of the case law, because I find in my deliberations that the case law does matter. We are a subordinate administrative body. Well, we have our home statute. We're dealing with a clash of charter values. That's what we're dealing with. Any of us can pick your own charter value, and you can say your charter value is more important than the other. And it's that clash in a secular society when it comes to religion, which is very dangerous, which is something that we as benchers need to reflect on. And we need to reflect on what the Supreme Court of Canada has said. In this case, the TWU case for the Supreme Court of Canada addressed, and this sign a very good point, of which I too want to hear from Trinity Western, which is the difference between the covenant today and the covenant then, but did address the covenant. And the Supreme Court of Canada struggled with balancing the two rights, the equality right and the right to religious freedom. Not dissimilar to the way we did. Not so long ago, in November, in Regina versus Bedford, the Supreme Court of Canada once again enunciated that precedent matters. That the rule of law and the common law is a precedential system. And that to deviate from precedent, as they call it, on the vertical axis, they gave themselves their own horizontal axis, they can do what they want. But on the vertical axis where we sit, you have to either have a new argument, as it were, or new facts. It can't be the recasting of an old argument. It can't be a different emphasis on the old argument. And so that's why I come back to the Trinity Western case and say there is a clash of values. It is a clash of values that is perplexing. Because Venture Science was nice enough to out herself, I'll out myself. I am a lapsed Catholic. I have faith. I don't have a lot of religion. I could not sign your covenant. I could not sign a lot of that covenant. And yet I hold on to my heterosexuality like I'm holding on to the wreckage. Why have you said that? That's like the hockey player in the baseball. I bring it out once in a while, but I don't do much with it.
I'm still giving off pings.
Is this really information that we need?
Can we get back to the matter at hand?
Yeah, we can. The only headline So when one reflects on religion, you know, religion and religious freedoms are really the foundation of Western society, and it's been fought intolerance. Religious freedoms were hard fought. Canada is somewhat unique in a country, in a fathering land of at least the English with the Act of Union and the prejudices that went on. We were a country that actually did not have a state religion, and yet we had religious intolerance. Ms. Harris spoke of religious intolerance. Religious intolerance by the religious, but also by society. But in the end of the day, religion is a set of beliefs, your individual beliefs. They are what someone at their core believes. We accept, in the Supreme Court of Canada, in the TWU's case, accepted that believers can congregate amongst themselves in a private institution like TWU. They can congregate. They can be amongst themselves, and in fact, they can exclude. That's what the TWU case says. They can exclude because they want to gather amongst themselves, love their own way. That's something that's so profound that this body ought not to interfere. Their covenant to allow people in or out is something that they have to decide amongst themselves. The question then comes, what can they do when they congregate? Someone earlier said that we don't have a history of religious post-secondary schools, but that is not entirely correct. One only has to go to the University of Toronto to see St. Mike's, to see Trinity. Go to London and see Huron, and see King's. Go to Windsor and see Assumption. Religious education at the post-secondary level is part of our Canadian heritage. That has been and continues to be what occurs. Do they all have them sign covenants? No. Do they require believers? Not all. I suspect most don't. But that's not the point. The point is, education as a religious extension is part of the religious belief. And that's also part of what the Supreme Court of Canada found in TWU when they dealt with teachers' development. So once you accept that they can congregate and they can educate, and they can go on and they can do that, and they can exclude, as they've done, the question is, what's next? Where do we sit? The question is, and again, I'm saying this because I don't think this part of the debate has been set out. So this is not because I have come down on a view. It's because I thought of a view. And because I asked for assistance. As I said, Ms. Syme's discussion was very apt. In fact, I stopped writing my 4 set of notes when she spoke. But it is an issue that I think that the TWU case dealt with. In that case, it was whether or not the BC College of Teachers would accredit the TWU students. And they undoubtedly had, we don't have the record of their debates, but they undoubtedly had a significant debate. Their debate ranged from the BC Human Rights Code to the Charter. And their decision was both the Canadian Human Rights Act and the BC Human Rights Act prohibit discrimination on the ground of sexual orientation. The Charter of Rights and the Human Rights Act express the values which represent the public interest. Labeling homosexual behavior as sinful has the effect of excluding persons whose sexual orientation is gay or lesbian. The Council believes, and is supported by law and the belief, that sexual orientation is no more separable from a person in color. Persons of homosexual orientation, like persons of color, are entitled to protection and freedom from discrimination in the law. That was the decision, the very decision, which sounds like much of what I've heard today, that the Supreme Court of Canada was considering. As I said, they went on and they talked about the right of religious freedoms and the right to congregate and the right to have an educational ability. I should add, in case people believe, and I'm not sure, I'm open to be persuaded, but I don't quite see that the public interest in teaching is different than the public interest we have. And I don't think that that public interest of making sure our children are educated in a secular society with the tolerance of a secular society is any different than our rule of law at that level. And Supreme Court of Canada acknowledged they didn't talk about obviously what we're doing, but said as much. But what the point was, and again, we're all looking at the same orb, and it's how we turn that orb and how we view the question. And if we accept that they can congregate, and if we accept that they can educate, the next question is where do we fit? And the Supreme Court of Canada, again back in the TWU case, said it cannot be reasonably concluded that private institutions are protected, but that their graduates are de facto considered unworthy of fully participating in public activities. And so I need help understanding. And I can look to TWU, I can look to the other speakers who have spoken today, and I'm sure there are many smarter, wiser, who have better notes than I, who can help us on this. But are we not limiting the participation of those who have the right to congregate in accordance with their beliefs, who have the right to educate in that while congregating, to participating in our society? It's an issue that perplexes me, because all these freedoms were hard fought. Freedom of religion was fought over centuries. The same-sex battles were fought over centuries. In fact, there are more people with scars on the same-sex fight than there are religious fight at the moment. It's a more open and raw issue. And I fear sometimes when I listen to the debates here that we are taking on an enormous responsibility in reorientating what we see as the balance between our charter values. That's what I'm concerned that we don't have, in part, and I mentioned this to someone earlier, a record that would sufficiently allow us to do what we're about to do. I mean, I personally would think a wiser choice would allow Mr. Ruby to go through his application and see what the law is. Now, some would say we're chickening out. I could give you my conditional vote after the debate and then wait. That doesn't make a lot of sense. There aren't going to be graduates from TWU for 3 or 4 years. But this is an enormous issue that we are grappling with. I looked for guidance in the TWU case. I actually saw the similarities as unassailable. But that's something I can be persuaded. And Ms. Symes did a wonderful job distinguishing certain elements, and I'm sure come the next attendance I'll hear others, and I thank her for that. But I still am not there, and I think the balance the Supreme Court of Canada struck is something that we have to be very, very leery to unstrike. And I think we also have to be leery. I don't know whether the record today would be sufficient to do otherwise. Just one last word. I do not ask you to change your covenant. It's your covenant. You do with it what you want. I don't agree with it. I won't sign it. But I'm not asking you to change it. For me to asking you to change it would for me to ask you to change your belief. That obviously is exactly the issue that we're here to talk about. Whether you have to change your belief, and whether the adherents of your belief, educated in accordance with standards that have been promulgated by the Federation, are allowed to participate in society, because we, at the moment, are the gatekeepers of who gets to participate in society. I say all this waiting to hear an answer, waiting to have some enlightenment. And I have to thank everybody who's spoken, because it has helped me, but I'm afraid I'm on my 5th set of notes, so I'll probably be back here on the 24th with volumes of notes, but thank you.
Thank you, Mr. Kelly. Before I call on the next speaker, I regret, I'm very saddened to have to inform Convocation that ex officio bencher and former Attorney General of Ontario and former Minister of Finance, James Flaherty, has died in Ottawa. And we, at the age of 64, We are obviously very saddened to miss at hearing the news of the sudden death of a colleague of ours, someone with whom, despite whatever political differences we may have had, I think I can speak on behalf of Convocation when I say that Mr. Flaherty was a true public servant and devoted himself to public service as a lawyer, as a politician, and as a minister of the Crown. And I'm deeply saddened, as I'm sure we all are, at hearing this news. And we extend our sincere condolences to Christine Elliott, his wife, MPP Christine Elliott, and his family. And our thoughts and prayers are with them at this time. So I'll call Mr. Campion. Mr. Campion, followed by Mr. Silverstein.
Treasurer, and through you and to benchers in Convocation, this debate is not a matter of personal preference or conscience. We have been provided with a legal process and deliberative context in which to make an objective decision. For that expert advice, we are much obliged to the Treasurer, the Law Society staff, our legal advisors, and those of Trinity Western, Federation of Law Societies, and many, many helpful interveners. May I join those benchers who spoke before in welcoming Trinity Western University representatives here today. I hope it cannot go unnoticed that you are here among friends. And so we have discovered close friends through association. As lawyers, paralegals, and citizens, freedom of religion and education are important values that in one case we are sworn and in the other case choose to uphold and greatly value. Diversity is a value that includes Trinity Western. The debate is not about individualized opinion. It is a debate centered on a community covenant requirement for law school admission at Trinity Western, and therefore accreditation by this law society in Ontario of a program that includes the covenant. If the covenant is exclusionary, it must be reviewed as an admission criteria or policy that impacts on our accreditation in Ontario. If the exclusion is based upon sexual orientation or personal intimate practices, it must be judged against our analysis of the public interest in Ontario. My present analysis is that the public interest is overwhelmingly in favor of eliminating all exclusion, direct or indirect, based on sexual orientation or private intimate practices. If, as I am presently persuaded, that the Trinity Western Law School admissions policies are based upon direct or indirect exclusion or feelings of exclusion based on sexual orientation, we at the Law Society are objectively obliged to refuse accreditation. This is not primarily about freedom of religion. This is centrally about fundamental human rights, most importantly, sexual orientation. As an objective decision maker, I will continue to listen and review any Trinity Western material and other responses to this debate. As a matter of process, may I respectfully disagree with one point made by Mr. McKenzie. If Convocation concludes that the community covenant requirement is discriminatory and not saved by freedom of religion, and accreditation is therefore refused, Convocation should not grant some form of conditionality. That would be a derogation of our decision-making authority. While Trinity Western could abandon its covenant or seek to amend it, it should only be permitted to do so in the context of a new application. Trinity Western should not be granted conditional approval to amend the covenant to meet what it may perceive to be existing impediments to Law Society of Upper Canada accreditation. I'm much obliged.
Thank you, Mr. Chairman. Mr. Silverstein?
Thank you very much, Treasurer. When Jose Bautista hits a ball 400 feet, the Rogers Center, that's going over the fence, the manager of the opposing team can't run out and say, move the fences back, move the fences back. If a Toronto Maple Leaf hockey player were to shoot the puck into the net, the opposing coach cannot say, move the goalpost back, move the goalpost back. And the same thing in football. You don't change the yardsticks in the midst of the game. And that's what I fear is happening today. We're losing track of what we're here to decide. The TWU application was approved by the BC Quality Assessment Board. And it was approved for meeting all the criteria, the quality assessment criteria. The application was also approved by the Federation of Law Societies. Thirdly, a special advisory committee was struck that also gave its approval. What I've been hearing today is superimposing new criteria. New criteria on what has already been approved. And that is the issue of non-discrimination. Perhaps the Federation and the BC Quality Assessment Board and all other approving bodies should have taken this into account earlier, and maybe they will in the future. But we have a situation where the application has met all of the criteria, and we as lawyers, following the rule of law, should acknowledge that they have done that, and not superimpose new conditions at the last minute dealing with non-discrimination. Much of what I've heard today is talking about discrimination in the name of equality. Think about it, discrimination in the name of equality. That's what you're ultimately going to be deciding upon, whether that is appropriate or not.
Thank you, Mr. Silverstein. Next on the list is Mr. Evans.
I'm grateful to have our three representatives here from Trinity Western. I've had the opportunity to speak to President Bob Kuhn and also to Janet Buckingham, and I appreciate those opportunities. Thank you, Treasurer, for convening this excellent convocation. I can't help but feel proud as a Canadian and as a venture to partake in this intellectual and eloquent conversation. My participation is not included. Canada is a fabulous country. How fortunate we are to be part of this country. But we do have blemishes. I salute Ventures Susan Hare and A.B. Go for their forceful presentations. My heart goes out to our First Nations and Chinese Canadians who have endured such suffering. Let us not take our privileges and freedoms for granted, but may we learn the lessons of our history. In my view, sexual orientation has nothing to do with religion. Homophobia has no place in the Christian faith or in any civilized society. Jesus never said or taught anything which was in any way homophobic. His teachings are grounded on inclusivity. To me, one of his most important teachings is that we should be non-judgmental. I am a member of the United Church of Canada. The moderator of the church is a minister who is in a same-sex marriage. Thousands of Christians, including many clergy, are in same-sex marriages. Religion is dynamic. It is rapidly evolving, just as society is evolving, and we as individuals are evolving. The members of the churches of 1950 or even 1980 would hardly recognize the institutions of today. Religion and society will no doubt continue to evolve, perhaps at a even more rapid rate. When the idea of same-sex marriage first arose, I was skeptical. When the concept was recognized by legislation, I accepted it. I now celebrate it as it allows people to live their lives in a way that is true to themselves. I expect that many of us have gone through or will go through this evolution in our thinking. I should make a caveat here in my remarks to mention that our eldest daughter was a student at Trinity Western University, and she received an excellent education and a great life experience. Trinity Western emphasizes the importance of virtue and morality. I suggest that these standards are equally important to the heterosexual and homosexual communities. Gays and lesbians do form part of the student community at Trinity Western, and I think we've been given the mistaken impression that by some speakers that they've been barred. That is not the case. They are accepted, they are cherished, and they're treated with equality and respect. They are there because they want to be there. In a recent message from President Robert Kuhn, and hope you won't mind me quoting your words because I don't want you to be too shy to say them yourself. Bob Kuhn said, yes, and I quote, "The essence of Christian values is found in Jesus Christ, who taught us to demonstrate love and respect for all people at all times, regardless of their faith, the color of their skin, or their sexual orientation." The Trinity Western Covenant asks students to respect the traditional Christian and societal definition of marriage as being the union of a man and a woman. I respect this traditional view of marriage, and I also respect same-sex marriage as permitted by recent legislation. I do not disagree with the covenant, but I do understand that gays and lesbians would feel ignored or excluded by the covenant. I have therefore suggested to the President that the covenant be amended or expanded to respect Christian marriage as a union between two people, or simply to respect Christian marriage. I diverge a bit from Fincher Callahan in taking the liberty of making a suggestion. In Rotary, we have a saying, it's really a line in a Rotary song: when something is wrong, let us straighten it out. We try to repair the problem, not destroy the situation. I anticipate that if the covenant is amended, such a change would have a positive impact for all the students at Trinity Western, including the potential future law students. I acknowledge that there are differing points of view in dealing with challenging issues. It is my hope that discrimination will continue to diminish in Canada, with the worldwide lessons derived from the horror of the Holocaust in World War II, and peacefully through our Charter of Rights and Freedoms, which is becoming more and more a reality in the everyday lives of Canadians. Is Trinity Western University a perfect institution? No, it is not. Are there any perfect institutions? No, there are not. I believe there is room for improvement for all of us as individuals and for all institutions. I sincerely hope that we all working together to share our varied opinions will achieve a result which will be satisfactory to the legal community, the Christian community, and the university community, including all its students. To do what we can to benefit the students makes our efforts worthwhile.
Thank you, Mr. Evans. Mr. Brent. Followed by Ms. Boyd, who is presently the last speaker on the list.
Mr. Wright on the phone.
I'm not encouraging other people. We'll go to the phones after Mr. Brett to see if there's anybody on the phone that wishes to add to the discussion. Mr. Treasurer, the floor is yours.
Fellow benchers and our visitors from Trinity Western. Like many of you, I have found this issue to be a very difficult one. My starting point is my own strong personal view that discrimination against individuals based on their sexual orientation is wrong and should not be supported. And in this regard, I've acted pro bono on a number of important cases. I acted in the M&H case, and my friend Andrew Pinto and I brought a case involving access to the healthcare system for lesbians and so forth. So the first right at issue here, the right not to be discriminated against based on sexual orientation is one that I strongly believe in. The second right at issue, the right to freedom of religion, is a right that I have to confess I personally have less affinity for. Perhaps because I'm not a religious person. And so for me, at the outset, the easiest approach to this issue would have been to simply go with my heart and take the position that discrimination based on sexual orientation is wrong and we should not accredit. But I'm not there yet. I'm struggling with this issue. I have to be frank with Convocation, I am struggling. I'm struggling with the breadth and the scope of religious freedom. Religion is protected in the Charter both under Section 2A, freedom of religion, and under Section 15. The same rights that we're talking about here, the right of sexual orientation, in the same section they expressly protect freedom of religion. And it's a right not to be discriminated against on the basis of religion. Now, rights in the Charter are not absolute. It's important to note that both Section 2A, freedom of religion, and Section 15 are subject to Section 1. And Section 1 says that there are reasonable limits prescribed by law that can be reasonably justified in a free and democratic society. So although we recognize both the rights to non-discrimination on the basis of sexual orientation and the right to freedom of religion, both of those can be restricted under Section 1. When I look at Trinity Western University, I say it clearly discriminates on the basis of religion. I mean, I wouldn't go to this university. I'm not of the Christian faith. It discriminates against people of the Jewish religion. If you're a devout Jew, you would not go to this institution. And incidentally, what I would say, as an aspect of the claim, it discriminates on the basis of sexual orientation and marital status. But it clearly, the whole notion of a religious institution is that people are entitled to get together on the basis of their faith in religious institutions and in educational institutions. And when you look at religious institutions, many of them are accepted in our society. We have Jewish day schools. People of the Jewish faith are entitled to send their children to be educated in a Jewish environment, in the Jewish faith, and they're entitled to exclude people of the Muslim religion or the Christian religion. And from that sense, they're discriminating on the basis of religion. So an element of religious freedom carries with it the ability for people of the same faith to get together on a faith-based basis and to exclude from those institutions people who don't share the faith and to discriminate against the people of those faiths on that basis. And what I need to understand more here are what are the limits within which TWU is entitled to discriminate on the basis of religion. I'm troubled by the examples. I have to say I'm very troubled by the examples that Linda Rothstein gave to us. If there was a religious institution that discriminated against their adherents on the basis of race, I don't like that. If there's, Ms. Rothstein talked about a yeshiva that separated men and women and said, you know, they can't study together. I don't like that. Ms. Miner suggested that it's okay to discriminate at the primary or the secondary levels, but colleges and universities are different. I need to understand why. I need to understand why in law we can draw those kind of lines. And so my first question here, and I say this honestly as someone who's struggling, I am struggling with these issues. They're not easy issues. What does Trinity Western say are the limits on the scope of freedom of religion? And how do they fall within those limits? That's my first question. The second issue that troubles me about the question we have before us now, is what we do as a law society if we choose not to accredit Trinity Western. And a graduate of Trinity Western applies to our licensing process. At present, when a graduate from an unaccredited institution applies to us, he's directed to the National Committee, or she's directed to the National Committee on Accreditation. And as I understand it, I haven't participated in it, but my understanding is what the National Committee does is they look at the substantive law that was studied and make a determination whether that are the same topics that we require accredited institutions in Canada to study. So if you studied in France and you studied the civil law but you didn't study the common law, you'd be directed to go away and study the common law. If you didn't study Canadian constitutional law, you would be directed to go away and study Canadian constitutional law. But I don't believe or understand that the National Committee process makes any inquiry into the law school or the legal institution where the studies take place and determine whether those institutions discriminate on the basis of religion or other factors. Because the decision we make here today, it seems to me, if we're going to say that we will not accredit a religious institution, to me, it's additionally offensive here that the religious institution discriminates not only on the basis of religion, but there's a religious tenet that suggests, well, we're going to discriminate on the basis of sexual orientation and marital status. But when we come back to it, essentially, I think what we're getting at here is that we would not accredit a religious institution because by definition, a religious institution is going to be discriminating against people that are not of that faith. And the arguments that we're making about access, those arguments apply equally to people who are not of the Christian faith. Not only are people from Trinity Western who are of the same sex orientation would not be comfortable there, someone who is of the Jewish faith or Muslim faith would not be comfortable there either. So there's multiple grounds of discrimination here. So when I come back to my point, which is the question of what we do with the NCR process, I don't believe that we make inquiries into it. And so my second question, and this is in part to Trinity Western, but also in part to the people here who are more familiar with the process than I am, is that if we refuse to accredit, does that mean that a graduate of Trinity Western is in a worse position than a graduate of a religious school from outside of Canada? So if someone applies to our accreditation process from a faith-based institution outside of Canada, and as I understand it, they go to the NCR process, there's no inquiry made into the fact that it was a faith-based institution, and they get admitted to our process, is that what's going to happen to a Trinity Western student? Or is a Trinity Western student essentially going to be denied entrance entirely? My next question. If the National Committee were to inquire into the religious nature of the institution and deny access to our licensing process, would that itself constitute a breach of freedom of religion? And I raise this question because it seems to me that one approach that the National Committee could take is to say, you're right, Mr. Brett. We should be making these inquiries, and we shouldn't have a different standard for people that come from religious institutions in Canada than we would have for people who come from religious institutions outside of Canada. And I say, if they start making those inquiries, do those inquiries themselves violate freedom of religion? And my last question is, if we deny accreditation to Trinity Western, and its students are in any event able to gain access to our licensing process, and in a discussion I had with Ms. Rothstein, which it's got me thinking, Linda, thank you. I mean, these are not easy issues. What she suggested to me was, yes, these people, let's not accredit, because we're participating, we're giving sanction to discriminatory conduct by accrediting. And I have a concern that she may well be right in what she says. But then what I say is that if we refuse accreditation and the students graduate and they come to the NCR, and the NCR says, well, actually, NCA, and the NCA process, wait, you studied all our topics. You don't need to do anything. Come on into our licensing process. Then what I ask is that approach to the problem itself in the public interest? And it may well be, but I think it's something that we need to think about here as we grapple with these difficult issues. Thank you, Treasurer.
Thank you. I'm going to go to the phone right now and just see if there's anyone on the phone that wants to be added to the speakers
The
list.
conference is no longer in lecture mode.
Is there anyone on the phone that wishes to be added to the speakers list at this time, considering that there's one speaker left on the list at the moment?
Yes, Treasurer. Brad Wright.
Okay, Mr. Wright, I'm going to let you go right now. Okay, Mr. Wright, you're on.
Thank you. In my high school yearbook, it said that my probable destiny was Hope Brad the First. I don't think that will surprise too many of you. If we allow religious freedom to trump other rights, then no other rights can be protected. There are no protected rights that cannot be sidestepped or sidelined under the guise of religious freedom. I think Mr. Mercer made a telling point when he pointed out that we should not allow discrimination to occur at one remove from us when we as the Law Society would not allow that discrimination ourselves. If we allow the discrimination to occur at one remove from us, there's no end to it. There is no end to it. What religious freedom means is freedom of your own conscience. That's not the same thing as imposing it on others. It is incongruous to ask law students who will become members of a law society in Canada, where they are required to respect and uphold laws, to sign a covenant wherein they thumb their noses at some of the most hard-won and important laws in the land. Now, for thousands of years, religions held that it was perfectly justifiable and proper to engage in human sacrifice. For hundreds of years, it was perfectly proper to ignore the commandment, thou shalt not kill, and burn heretics at the stake. For hundreds of years, religions held, in the face of scientific evidence to the contrary, that the sun revolved around the earth. No problem in believing that the sun does revolve around the earth. There's no problem in believing that other people are heretics. The problem arises when you impose your religious views on other people to their great harm. When two freedoms bump up against each other, we need to come down on the side of the freedom that does the least harm. And the freedom, the protected right that does the least harm in this circumstance is the one that prevents institutions, particularly legal institutions, from discriminating against other protected rights. Now, I missed part of it, so if this point has been made, interrupt me, but the very finest treasurers that the Law Society has ever had, one of the very finest human beings I've ever known, would not have been allowed to go to that university. That's, in a word, ludicrous. We like to think that we're independent actors, but the reality is humans and human societies obey the laws of physics. It's our hubris that thinks we don't. Biologically speaking, embryos all start off female. If X chromosome is present, then at about the 6-week mark, the embryo receives a chemical bath which converts about 52% of them into males. That's an extra step, it's a complication. As a result, there is a slightly larger number of male embryos that miscarry because of this extra complication. By the way, it's the last time men are more complicated than women. Born, we become much simpler than they are, as they well know. In any event, if something goes slightly awry at that moment of the chemical bath, well, you could end up with a live birth featuring somebody with female sensibilities and male genitalia, or the opposite. And our First Nations, a lovely expression to describe somebody in that situation, two-spirited.